Please, Lordship, I'd like to mention item number 2, my Lord. Lordship, I'm praying for some accommodation in this matter.
Why?
Lordship, the arguing counsel is still under bereavement, my Lord.
What happened?
Lordship, someone in the family of the arguing counsel has expired, so matter may come up after 2 weeks.
Mr. I can learned counsel for the appellant has sought for accommodation on the ground that the conducting counsel, Mr. S. General, is in bereavement. The same, the prayer not be objected to by Mr. H. R. Nath, learned counsel for the respondent, and Miss. You are also appearing.
Same.
Pray aloud. Please this matter after 2 weeks.
Highly obliged, Lordship.
Bless you. Please, Lordship. Lordship, I beg to mention item number 3, Lordship. For 3 weeks' time, Lordship, since the conducting counsel is still on medical leave.
Oh. On pre-made by petitioner, please this matter after 3 weeks.
Obliged, Your Lordship.
Right, Lordship.
Please, Lordship. Lordship, item number 4, conducting counsels from Delhi said that he was unaware, Lordship, that he had to apply for VC. He was going to appear. I'm also not on record. He just briefed me to apprise the court, Lordship, that he's unable to appear today.
Yes, who's
My Lord, I'm there for the statement, petitioner. Lord, I have no objections.
Mr. Learned Counsel has some sought for accommodation on behalf of the respondent on the ground that the Learned conducting counsel is indisposed on grounds of personal difficulty. Mr. Jain Rinja, Learned GA, appearing for the petitioner state, has no objection to the prayer made. Accordingly, as prayed for, this is matter after 2 weeks.
Deeply, Lord.
From supplementary list, item number 1.
May it please, Your Lordship.
Yes.
Your Lordship, that the petitioner in this instant bill of fiction is the younger brother of the accused person, Sri Ravi Debarma is the petitioner, and accused person Pradeep Debarma, Your Honor. My Lord, that the fact of the case that on the 31st of July 2023, an information was received by DSP Jemairam that one vehicle, Hyundai vehicle, is approaching from Silchar to Shillong, suspected to be carrying some contraband. So the same information was passed to the SP of Isantia Hills, and Isantia Hills district SP has endorsed and direct Jemairam to set up Naga checket at Umtra village in order to intercept the vehicle. So on the 31st of July 2023 at 9:30, the suspected vehicle was intercepted. On interception of the vehicle, there were 2 occupants. One is Shishir Debarma and the second is Pradeep Debarma. And Shishir Debarma is the driver of the vehicle, and Pradeep Debarma is the passenger who is the present accused in this instant application. My Lord, on after interception of the vehicle, and the DSP Jemairam informed the OC of the Clarion PS to depute officer for further search and seizure of the vehicle. So on deputing of the officer, SI S. Thamar arrived and searched the vehicle. On searching the vehicle, it is alleged that there were around 37 number of suspected contraband wrapped in the brown tape retrieved from some parts of the vehicle. So 37, which amount to the total weight of 41 kg. Out of 37, 37 packages with amount to the weight of all is 47.157 kg. Therefore, my lord, the case was registered under declared PS and the same was investigated.
The substance was tested.
Sorry?
Substance was tested.
Yes, it was tested, preliminary test was done.
Preliminary test, no doubt.
Yes.
What was
Yes.
it?
Sorry?
What was the result?
The result is negative for ganja, my lord. So, and the case also was, the IO has charged the case, my lord, and at the same time, the Honorable Trial Court at Cleariat has framed the charged the case, my lord. And during the pendency of the case, of the time of the case before the trial court, my lord, one occasion of bail have been preferred and it was deemed to reject under the rigors, application of rigors, section 37 of the NDPS Act, my lord. My lord, for the convenient reference, my lord, I would like to refer the two accused person in this instant case. One is Shishir De Burma as accused number 1 and Sri Pradeep De Burma as accused number 2, my lord. And accused number 2 is the present accused for this instant case, my lord. My lord, I contend my application on 3 aspects of my contention, my lord. That the first is that the recovery is doubtful and sampling procedure is not in accordance with the Narcotic Drugs and Psychotropic Substance Seizure, Storage, Sampling and Disposal Rules 2022. Second, my lord, that the accused number 2 has been arrested on the 1st of August 2023 and he is in custody for more than 1 year, which is almost for 2 years, my lord. And the third, that the accused person having a clean antecedents, there is no criminal court known against him, my lord. So, in order to substantiate my ground, my lord, I further would like to submit, my lord, that on the first ground, that the sampling were not as per the mandate of the law, my lord. See, my lord, what happened there after the seizure? After the seizure of the contraband, the suspect contraband,
Yes.
on the 31st of July 2023, and the sample and the police kept those contraband with them, the IO kept with him for 5 days, and after 5 days, that is on the 4th of August, they were produced before the magistrate for collection of samples. So what happened, my lord, that this is not as per the mandate of the rules, as per the mandate of the law. As far as possible, though in the previous, in the standing order, it is within 72 hours, but however, in the rules, it said as early as possible, they have to forward, once the seizing officer sees, they have to forward to the nearest police nearest PS officer in charge, and the same at the areas has to forward and put an application before the magistrate for collecting of the representative samples. However, unwarranted, unauthorized, that 4 days or 5 days of this suspected contraband were kept with the police. And however, on the 5th day, that is on the 4th of August 2023, it was brought before the magistrate. When it was brought before the magistrate, all the 37 suspected packages were kept into one bag, which is marked as Master Pack A. So when it was brought, so all these 37 were weighed before the magistrate, were weighed and having different weight. So what happened, my lord, that in this instant case, out of 37, the magistrate have taken only from 2 packages for representative sample. That is, as I have also enclosed, my lord, the certificate that issued by the magistrate under section 52A in the page number 43, my lord, Annexure 6. My lord, I have put also the type copy of the Annexure 6, since this visibility is very not very clear, my lord. So in this certificate, my lord, in that master packet A, page number 46, Annexure 6, 43, my lord. The type copy is 43A, 43B, 43C. So in this
Yes.
Yeah. My lord, in this certificate, where is as per the mandate of section 52A, from the master packet A, there within the master packet A there are exhibit A1 up to exhibit 37. That's mean 37 packages. However, towards the end of the certificate, my lord, in the page number 43C, my lord, it is mentioned that, my lord, where drawn in my present and sample mark containing sample exhibit B, suspected marijuana weighing 26.06 gram, inclusive of weight of the plastic weight 0.86 gram. Sample exhibit B2, suspected marijuana weighing 12.21 gram, inclusive of weight of the plastic weight 0.71 gram, were extracted from the master packet A1, that within the bracket that is only A37 and A30 in my present, my lord. So my contention here, my lord, that the exhibit 30 and exhibit 37 is weighing 1.046 and 1.027 kg. So respectively, Your Honor. Only from this, which amount to 2 kg only, my lord, that the representative sample were collected. So my contention here, my lord, that only now this case, now only the remaining 35 packages is unknown, because it's never been, it's neither open nor sample were collected. It was sealed and packed just like that, only from 2. So in this instant case, my lord, with the fact under such circumstance, my lord, that the content of the 35 packages cannot be said or considered to be a ganja, my lord, because it has to be, we cannot consider certainty and beyond reasonable doubt that all the packages were contained of ganja, because it's never been opened nor has sent for chemical examination, my lord. Therefore, in this instant case, my lord, that we can we can consider only for the 2 packages that is contraband, my lord. Without examination, we cannot consider as a contraband, my lord. Even in the preliminary test also was not done from all packages. So now even for in the magistrates also have taken only from 2 packages. So the rest cannot be considered. Therefore, it does not fall under the commercial quantity of this instant case, my lord. And further, my lord, in order to substantiate my contention, I would like to refer to one case, my lord, as a reference in page number 7 of my petition, my lord. This is in High Court of Allahabad High Court, my lord. What happened in this case, my lord? I'll just, my lord, in my list of book number 4, Wali Hassan was a state of UP. Number 4, my list of book number 4, my lord.
You have not page marked your compilation,
Page.
Mr. War? You have not you have not page marked your compilation, so I don't know where.
My list of book, number 4 in the list.
Number 4, but where is that number 4?
Sorry.
Please.
What happened in this case, my lord, that the Allahabad High Court observed in this case that there were 91 packets of ganja weighing 201 kg were found and recovered in 8 bags, my lord, from one vehicle, truck vehicle. So out of these 91 packets, weighing of 201 kg, only 1 kg of ganja were sent for chemical examination, my lord. So the question here arises that the collection of sampling were not as per the mandate of the standing order or the mandate of section 52 of the NDPS Act, my lord. So the relevant paragraph of this case, my lord, is paragraph number 13 in page number 7 of the case, my lord.
Yes.
It was observed, considering the submission of both the parties and keeping in mind the twin condition of section 37 of NDPS Act, and perusing the evidence on record, is very much established that sampling was not done was done contrary to the standing order instruction number 1 of 1989 and dated 13/6/1989, which are mandatory in nature, and such chances of applicant conviction is weak on the basis of sampling of contraband done in the present manner, as well as on the basis of the ratio of the judgment in the case of Union of India versus Shiv Shankar Kishri Supra, larger mandate of Article 21 of the Constitution of India. Without expressing any opinion on the merit of the case, I am of the view, applying section 37 of the NDPS Act, that applicant is entitled to be released on bail. The same is very similar case as what this instant case, 91 packets, 201 kg, and only 1 kg was sent, 1 packet was sent for chemical examination, and the rest cannot be considered at this instant case, my lord. I beg your lordship, I have referred one another case, that is case number 2 in my list of book, Rajan Singh versus Directorate of Revenue.
Yes.
My lord, in this case also the same happening, that the samples were drawn not according to narcotic drugs and psychotropic substances, seizure, storage and sampling and disposal rules 2022, my lord. That the seizure were supposed to take the seizure. Here in this case, what happened, my lord? Heroin was alleged to be recovered, and samples were taken only for 1 pouch. So the rest of the pouches were neglected, and therefore the Honorable High Court of Rajasthan also, my lord, has observed that in such case, my lord, that prejudice caused to the accused, my lord. So relevant paragraph, my lord, in the page number 4 of 7, paragraph 7, my lord, page number 4 of 7. In this instant case, as per the prosecution case itself, samples were not drawn from each pouch. The samples of contraband heroin were drawn on the 1st of March 2023 during the certification of inventory of seized goods, and thus the arguments of the counsel for the petitioner that it cannot be ascertained beyond all manner of doubt that recovered contraband was of commercial quantity is worth considering. It was imperative for the seizure officer to draw samples from each pouch in pursuance of the rules of 2022, my lord. In identical fact case, benefit of bail has been granted by the coronate bench of this court, my lord. So the same fact or circumstances, my lord, that exists sitting in my case, that the rest of 35 remaining packages is not been collected with sample for chemical analysis, my lord. So therefore, my lord, at the utmost certainty we cannot consider it that the rest of 35 contraband packages are the ganja, my lord. My lord, even I have also enclosed the rules 2022, my lord, the last of the number 5 of my list of book, my lord. My lord, in the rule number 10, that's page number 20, my lord, rule number 10, it says that one sample,
yes,
rule number 10, my lord, one sample in duplicate shall be drawn from each package and container seized, my lord. And further, when the packages and containers seized together are of identical size and weight, bearing identical mark, and the content of each package give identical result or color test for a drug identification kit, conclusively indicating that the packages are identical in all respects. The package and container may carefully be bound a lot of not more than 10 of packages or containers, and for each of lot of packages and container of one sample in duplicate shall be drawn. Provided that in the case of ganja, poppy straw, and hashish charas, it may be bunched in a lot of not more than 40 packages or container. In case of drawing a sample from a lot, it shall be ensured that representative sample in equal quantity is taken from each package or container of that lot and mixed together to make composite whole from which the sample are drawn from that lot, my lord. So in this case, nothing as such, even as mandate, my lord. So in this, the rule is, my lord, that in subsection 4 of the section 52A of the NDPS Act, provides that, my lord, in all the photography, sampling, and all procedure has been done under the recourse of section 52A shall constitute the preliminary evidence, my lord. So what I'm trying to state here, my lord, that as far as the fact and circumstance arise from this case, only the exhibit A30 and exhibit A37 is compliance as per the section 52 and the rules, and these are the only packages which amount to 2 kg of suspected ganja can be considered as preliminary evidence, my lord. So the rest, my lord, that the rest of the remaining cannot be considered, my lord, without the expert evidence of the in this case, my lord. Further, my lord, I would like to submit regarding my second contention that the accused, my lord, that in this case, my lord, that have been languishing in the jail for almost 2 years, my lord. So the prosecution the IO has proposed 6 cited witnesses, and only 3 have been finished till date, my lord. So, my lord, this since the charge sheet and with the existing fact and circumstances and discrepancies in the case, my lord, that the prolonged incarceration of the accused person, Your Honor, will amount to infringement of the basic right under Article 21 of the Constitution of India. Your Honor, my lord, that the rigors, the embargoes under the Section 37 cannot fetter the basic right of the accused under Article 21, my lord. It's almost 2 years, my lord, in this case, and only 3 witnesses has been examined, Your Honor. So there are a catena of case, my lord. I have referred also in Ankur Chowdhury, my lord, that even your lordship have referred in many cases, my lord, that in the event, even in the case where it's commercial quantity, when there's such prolonged incarceration also, my lord, that it cannot fetter the right. Even in recent case, my lord, have observed in the case of Sanjay Singh, my lord, Sanju Singh versus State of Meghalaya, my lord, that the relevant paragraph I have already mentioned, my lord, that the embargo of Section 37 cannot overrule or override the right and personal liberty of the accused under Article 21, my lord. And last, my lord, that my contention regarding the antecedent, my lord, the accused person here does not have any criminal antecedent against him, my lord, which is one of the the main consideration, my lord, while considering while observing the rigors of Section 37, or one of the conditions that provided under the Section 37, that is antecedents, my lord. And the accused here, the instant Pradip Debarma, does not have any antecedent, does not have any criminal antecedent known against him, my lord. However, I may mention that the co-accused Shishir Debarma is having another case in Tripura, my lord, related case, except for the present accused person who does not have any criminal case known against him, my lord. So, my lord, before I conclude my submission, I would like to refer again to the case of Rajan Singh. case of Rajan Singh, my lord, in the page number 5, paragraph number 8, my lord, in regards to applicability of section 37, my lord.
Para 5.
Para 8, my lord. So, para 8, page number 5, my lord. Rajan Singh versus Directorate of Revenue Intelligence, my lord.
Yes.
Section 37 of the NDPS Act does not create an absolute embargo for grant of bail. Further, while considering an application for grant of bail, it is not required for the court to record positive finding and the accused is not guilty. The only requirement of law is that the court would look at the material in a both manner and reasonably see whether the accused's guilt may be proved. The satisfaction which courts are expected to record, that is, the accused may not be guilty, is a prima facie based on the reasonable reading, which does not call a meticulous examination of the material collected during investigation. Further, in paragraph number 9, that considering overall fact and circumstance of the case and the fact that the petition does not have criminal antecedents of similar nature, so also in the view taken by the Honorable Apex Court and coordinate benches of the court in the cases referred in supra, I am fully satisfied that the conditions contained in section 37 of the NDPS Act are fully satisfied in the present matter. In view of the above, I deem it just and proper to allow the present bail application. However, it is made clear that any observation made herein above shall not influence trial in any manner. So, my lord, on the existing prima facie fact and circumstance of the case, my lord, as I have stated, the sampling was not done. The remaining we can consider only for the 2 kg of the contraband, my lord, in this case, and the accused has been languishing in jail for almost 2 years. Only 3 witnesses has been examined, and he has a clean antecedent, no criminal records known against him. Based on these 3 main contention, despite of the large discrepancy of delay of submission of the collection of the sample, my lord, which is, I do not want to stress much on that, but my lord, based on these 3 main contention, my lord, this contention provides a reasonable ground, my lord, that to observe and that the applicability of rigorous succession is not against the accused person, my lord. So the accused person is a father of minor and a wife at home waiting you, my lord, who depend on him, my lord. So this is all my submission, my lord. Fellowship.
Lordship, I have only a few points, Lordship, if I may submit, Lordship. Firstly, Lordship, the accused person, Lordship, he is in conscious possession of the illegal contraband substance. He is aware that the vehicle is loaded with the substance and it is kept concealed in the vehicle, Lordship. In this connection, Lordship, I'll take to page page 20, Lord. This is the statement of the present accused. Page 20. He is very much aware, Lordship, that the vehicle is loaded with the contraband substance. Page 20, Lordship.
Yes.
Shall I read it, Lordship?
Please.
Myself by profession was a farmer. On 31/07/2023 at around 8 p.m. I received a phone call from one Shri Paresh De Burma of Tripura to come to Rani Bazar, Tripura, to go to Limkra, Shillong, Meghalaya for some business. On meeting him, he instructed me and the driver Shri Shishir De Burma, the first accused, to go to Shillong to deliver the consignment / ganja, which was already loaded and kept concealed in the vehicle by Shri Paresh De Burma. On 31/07/2023 at about 9 a.m., I, along with Shishir Debarma, left Rani Bazar, Tripura for Shillong. I was told by Sri Poresh Debarma that the consignment ganja was ready for delivery and instructed me and Sri Shishir Debarma to deliver the same at Limekra, Shillong, Meghalaya. When asking Sri Poresh Debarma to whom the consignment is to be delivered, he only said that when we reach Limekra, Shillong, just make him a call and he will send the receiver and hand him over the said contraband to that person, and that person will pay me 5,000 and then come back. I am also to state that I did not know how many kilograms of ganja that was kept concealing inside the vehicle, as everything was said done by Poresh Debarma. He has not given me any money. I was supposed to get the money for 5,000 only from that unknown person once the consignment is delivered. But on the night of 31/07/2023, in between 9:30 to 10 p.m., myself and Teresa were detained along with the vehicle which I was traveling at one of the police checkposts at Untara, Klirach, Meghalaya. So he is aware, Lordship, but still they were transporting the ganja from Tripura to Shillong. That is the first point. Secondly, my lord, the petitioner is involved in interstate illegal smuggling of contraband substance. So this might be a larger drug syndicate. He is involved in interstate supply of drugs, ganja. So it might be involved some larger group. So that is also one thing. And they were using a vehicle with the fake registration number plate. When the IO had requisitioned the report from the MBI, it was found that they are using the fake registration plate. It is in the charge sheet. It is reflected in the charge sheet.
Page?
Would you page? Page 21, last paragraph. Page 21, last paragraph, MBI requisition report.
Yes.
I'll read only the relevant line. The last line, last line.
Yes.
On examining the report, it was found that the seized vehicle with the above chassis and engine number have a registration number, Bihar registration, 01BS 2941.
You're reading which last portion means?
Lordship,
You're reading which part?
last from page 21, the last sentence, the last line.
On examining.
On examining the report, it was found that the seized vehicle with the above chassis and engine number have a registration number BR01BS 2941, and the registered owner was Vikas Kumar, son of so and so from Patna. And they are using the fake registration number plate under AS 23J 0171. AS in the same paragraph, page 21, AS 23J 01-0171.
But the actual number?
The actual number is Bihar number.
What is the Bihar number?
BR 01 BS 2941. They are using the fake one, AS Assam registration.
Was any charges framed under this?
This also, I think it is there.
Yes.
So, Lordship, yes. So another aspect, Lordship, is the regarding the trial, regarding the progress of the trial, Lordship. Progress of the trial. The charge sheet was filed on 21/12/2023, and the charge were framed on 9/4/2024. There are 6 witnesses.
Charge sheet was filed on
Charge sheet was filed on 21/12/2023. And the charges were framed on 9/4/2024. And thereafter, the evidence was fixed.
charge sheet filed on
21/12/2023.
charges frame on.
Charges framed on 9/4/2024.
Where is it?
It's in the order,
Order.
page 39. Page. I'm going by the order of the trial court because the trial court order is not here. It's not enclosed, Lordship. So I'm going by this order enclosed here.
Which portion?
Page 39, the second last paragraph.
Charge frame on.
Seen the case was charge sheeted on 21/12/2023 and charge were framed on 9/4/2024, and the date for evidence started from 3/5/2024. So it was the first evidence start on 3/5/2024, and thereafter the witnesses were recorded. My learned friend submitted that so far only 3 witnesses have been recorded, but there's nothing here. Must be the court must have recorded more than 3. And that is
This is the bill order.
and regarding the weight measurement and drawing of samples, Lordship, it is done. I would like to take your Lordship to page 20 of the bill petition, Lordship.
Yes.
Page 20, the last paragraph. Drawing of sample and note. On 4/8/2023, self along with staff of PI cleared at court, along with the seized exhibits, appeared before Shri F.R. Marak, Judicial Magistrate First Class, East Khasi Hills, and produced the seized exhibits before the Honorable Court for drawing samples of the seized exhibit for FSL analysis. Note, next page. It may be noted that in the court, in the courtroom, in the presence of magistrate during weight measures of seized suspected marijuana containing 37 brown packets, and on weighing all the 37 packets which were taken out from the master packet marked as Exhibit A and found to be total weight is 46.926 kg. It is also to be noted that from the master packet Exhibit A, samples were drawn from Exhibit 37 and Exhibit A30 packets, which is marked as Exhibit B1 and Exhibit B2 respectively, and the sample drawn, that is Exhibit B1 and Exhibit B2, are accordingly packed and sealed in 2 yellow envelopes duly consigned by the Honorable Magistrate and shelved for sending the same for FSL analysis. After completion of all legal formalities, the Exhibit A1 to Exhibit A37 were repacked and sealed in the same gunny bag, which is marked as Exhibit A, master packet. Further, after receiving the court order dated 04/08/2023 passed by the Honorable Court of the Magistrate Clarion in respect of the weight and measurements of the seized suspected marijuana and sample drawn from the seized exhibits for sending for FSL analysis, self-submitted an inventory report of the weight measures and of seized suspected marijuana as samples drawn to the Honorable Court of the Judicial Magistrate First Class, East Khasi Hills.
East Khasi Hills or East Jantia?
East Jantia Hills. I received certificate as required under Section 52A of NDPS Act provided by the Honorable Court of the Magistrate. in this regard. So the inventory also was prepared and sent for FSL. As per FSL, it is tested positive. So this is my submission. This is all my submission.
If I may, Your Lordship. My Lord, that Learned Friends has raised the issue regarding conscious possession. However, my contention is only with the specific that in sampling were done in violation of the standing order and the rules, my Lord. Now, question of intermediate and question of commercial, whether this case is commercial or intermediate quantity. So that's why I have already elaborated, my Lord, that because only from two exhibit A30 and A37 samples were collected, my Lord. Even my Learned Friends has already read it through the charge sheet. There's no dispute, my Lord, in the charge sheet. That's why I do not bring anything what have been going with the trial, my Lord. That's all I have to submit, my Lord. Even my Learned Friends has stated regarding the have read the statement of the accused, my Lord. He said that I do not know what is the weight of ganja. Though it's not just my contention here, my Lord. Since my Learned Friend has raised that, he doesn't know the weight of the ganja, my Lord. Now the question is whether it's all the 37. My question is only that whether the remaining, what happened to 35 packages. That is the question. Now this case, that's why I pray your my Lord to consider that only those, as per the rule and catena of judgment, my Lord, that only those samples were sent for FSL only. That can be considered as this stage, my Lord, without going with the deep thought of the merit of the case, my Lord. So regarding the rest of the rebuttal from the my Lord prosecution, he already mentioned that. Even I also mentioned that only 2 samples were collected, my Lord. This is only my ground. And for regarding with the incarceration, my Lord, almost 2 years, my Lord, when it's already caused prejudice to me. Now I have been tried under section 21C and section 29 of NDPS, my Lord. Now the case, because the presumption under the section 54, my Lord, the presumption is first that the prosecution has to establish that the possession, my Lord. Now the person, whether I am in possession of commercial or possession of intermediate, that has to be established during the trial by the prosecution. That's why I do not want to raise that question, my Lord. So regarding the statement which is read by the Learned Friend, my Lord, I think my Lord is very well versed with the case of Tufan Singh versus State of Tamil Nadu, that any statement made under section 67 NDPS or 161 before the police is not ultimate piece of evidence, because the case has been come during that. Now we all have reached half of the trial, my Lord. So I do not want to concentrate all stress on all this aspect, but only the aspect of the sampling, my Lord. So
that is why, see, that is why a question was posed to the PP as to whether any charges were framed or was framed as regard the vehicle.
No, my Lord. Only 20. Only I have mentioned there, my Lord. There's no. That's why I don't want to counter regarding the interstate.
Lordship, regarding the conscious possession, he is aware that the vehicle is loaded with the ganja, and they came to Shillong to carry it to Shillong, and on checking, the 37 packets of ganja were recovered. Even if he does not know the weight of the total weight of the ganja, but on checking it, 37 packets were recovered from the vehicle.
My Lord, they have recovered 37 packages suspected ganja, my Lord. Only 2 have been sent for chemical analysis, which is confirmed of cannabis present, my Lord. That is the case.
I leave it to your Lordship. Lordship may pass the order. This is only for one accused, Lordship. There are two accused. Yes. Only for one. The one accused is involved in another case in Tripura.
heard Mr. Arwar, learned counsel for the petitioner. Also heard Mr. H. Harmi, learned additional PP for the state respondent. The learned counsel for the petitioner has submitted that the case of the petitioner hearing is that his brother Shri Pradeep Debarma was arrested.
Lordship, if I may interrupt, Lordship, regarding that fake registration number plate, Lordship. This observation of the IO is there at page 23. Lordship, page 23.
No specific charges for him.
Lordship, as further in the
Where is the
second paragraph, page 23, second paragraph, 1, 2, 3, 4, 5, 6, the sixth line, Lordship, second paragraph, sixth line. Further, as per MBI inventory report and SCRB report, the accused person had used the vehicle conveyance with fake number plate with no any document of the vehicle in carrying out their illegal activities. Efforts are made to arrest the owner of the seized vehicle having chassis number so and so and engine number so and so, which after investigation be able to get it registration its registration number as BR01BS2941, and its first owner is Shri Bikash Kumar of Patna. But on 19/10/2023, the said owner, through his representative, had produced a copy of the sale agreement to the effect that on 01/04/2023, he had sold out his vehicle to Shri Uttam Kumar of Bihar only, at the rate of 2,10,000 only in cash. In this regard, a debility message was sent to the officer in charge of Sarai Police Station, Bihar, requesting to detain, arrest Shri Uttam Kumar, second owner of the detained vehicle, who is suspected to be involved in conspiracy in the incident case, but no reply as such from the said concerned officer in charge of Sarai Police Station, Bihar. Until date, none have come forward to take claim of the seized vehicle. Yes. The remaining is regarding the involvement of the other accused in the another criminal case.
My lord, neither the IO has been proposed the charge against accused under the section, relevant section, nor the court have been charged. Even the charge does not mention anything regarding that charge under the pertaining to the vehicle. My lord.
yes. Kunto? That his brother, along with one person, namely Sri Shishir Debarma, were traveling in a vehicle bearing registration number AS23J0171 from Tripura and proceeding towards Shillong on 1/8/2023, when they were intercepted. You had started from your destination on which date? On 1st?
31st,
On
ma'am.
31st?
31st was interception. The rest of the procedure was done on the next day here.
Okay, intercepted on 31st. So you had started from your destination on 31st itself?
Yes, yes, ma'am.
I'll put it in more. 31/7/2023. When? Kung tungong the last line? Yeah, on 31. However, at around 9:30 p.m. on the same day, they were intercepted by police personnel belonging to the Anti-Narcotic Task Force, under bracket ANTF, at a place called Umtira,
Umtra.
UMTYRA, on the National Highway. That's National Highway 37.
National Highway N6, NH6.
NH6, National Highway 36. Accordingly, on being so intercepted, their vehicle was searched, and about 37 suspicious packages were recovered from inside the vehicle. Accordingly, both the occupants of the vehicle, including the brother of the petitioner, were detained by the police. Since the contents of the said packages appears to be suspected contraband substance, accordingly, the police, taking cognizance of the case, had registered. Where's the FIR? Taking cognizance of the case on an FIR.
Page 12, my lord.
On an FIR filed on 1/8/2023 by Shri J. Myram, MPS, DYSP, East Dainty Hills District, Clear, indicating the said interception and seizure of the said suspected packages, wherein the suspected contraband substance is said to be marijuana, under bracket ganja. Accordingly, thereafter, clear at PS case number 55/8 under bracket 8 of 2023 under section 20 under bracket B small b under bracket 2 Romans 2 under bracket C 29 of the NDPS Act was registered and investigation launched. It is also the submission of the Learned Council that in course of investigation, the said seized substance was produced before the learned judicial magistrate at Clarion on 4th, isn't it?
Yes.
On 4/8/2023, wherein it is said that I only have 37 packages, wherein out of the 37 packages, 37 packets containing the alleged contraband substance, only from packet marked as A1,
A30,
A13,
30,
A30 and A37 was sample taken out, which proved to be positive for marijuana. On the basis of this evidence and other determining factors, the IO investigating officer had filed the charge sheet on
21/12/2023.
21/12/2023, with a prayer for with the opinion that a prima facie case has been found well established against the accused person who and they are to stand trial before the competent court of jurisdiction for the offence as alleged, for the said offence under the NDPS Act as alleged, which offence among others included that of section 20 and bracket C of the NDPS Act, referring to seizure of commercial quantity of contraband substance. It is the further submission of the Learned Council that at this point of time, evidence of the prosecution witnesses have been recorded, and out of 6 witnesses, 3 of them have a recording of the evidence of 3 of them have been completed. The Learned Council has, however, submitted that the petitioner has a threefold contention in this regard. Firstly, that records would show that the manner in which the sample was taken from the said seized quantity of the alleged contraband substance, that is the 37 packets, when they were produced before the learned magistrate, being kept in a single container or bag. Is it a bag or container?
Sorry.
They were all kept together in a bag.
Yeah, they kept together in the bag.
Kept together in a bag, form like a container. Only 2 of the said packets were brought out for sampling. The Learned Counsel has submitted that firstly, when the said alleged contraband substance were seized on 31/7/2023, they were produced in court only on 4th,
Yes, my lord.
on 4/8/2023. The same not being produced immediately before the said magistrate, there is every doubt that the contents that was produced before the learned magistrate may not be the same one as was same one which was seized. Be that as it may, the Learned Counsel has also submitted that since out of 37 packets, only 2 packets were taken out for sample, which is contrary to the mandate of the relevant provision of the NDPS Act. What is the provision? Section 42.
52.
42.
Yes, 52A, my lord.
52.
Because the rule was legislated under the pretext of section 52A.
Last line. Relevant provision of the NDPS Act, that is section 52 capital A, and the related rules of
2022, my lord.
Rules of 2022, which mandates that sample has to be taken from each and every seized packets, therefore it can be presumed that whatever has been seized may or may not be marijuana. However, whatever has not been taken out as samples from the other 35 packets cannot be assumed or presumed to be marijuana. The contention of the Learned Counsel on this issue is that of the weight of the said alleged contraband substance taken out for sample, the same would only constitute what was the total weight that was
2.073, my lord.
2.073 kg.
Yes, my lord.
Belum tahu fully going to you. Which was taken out for sample. That is 2.2 out of the total weight of the 737 packets set to weight about, what is the total weight?
42 point.
Lordship, the total weight of the 37 packets is 47.157 kg.
47.157 kg.
And from those two packets
20.
which were tested, the total weight is
2.073.
2.073.
Atau pulih biang tu i lain. Oh. Therefore, it cannot be said that the legally seized quantity falls under commercial quantity under as could be seen from section 20 and bracket C of the Act. Accordingly, it can be said that the accused person in question though not admitted but assumed to have been caught to be in possession of an intermediate quantity of the alleged contraband substance. On this ground alone, the Learned Counsel has submitted that the accused person is entitled to grant of bail. In this regard, the Learned Counsel has cited the authority found in the case of Wali Hassan versus State of UP. Wali Hassan, isn't it? Or Rajan Singh?
Wali Hassan, my lord.
Wali Hassan versus State of UP. Para 13.
13, my lord.
In the case of the kanisa ay kani kayo mo ni. Yung Wali Hassan ni. Yung step. Wherein at para 13, the Honorable, which code is this? This is from which code?
Honorable Chandra Kumar.
UP.
Yes, my lord.
The Honorable Allahabad High Court
Allahabad High Court
has held as follows. I took 13 more. This is another supporting judgment in this on this point.
Yes, my lord. Ranjan Singh.
Rajan Singh.
Yes, my lord.
Another authority cited is the case of Rajan Singh versus Directorate of Revenue Intelligence through Standing Counsel. Nothing is said here. Wherein the Honorable Rajasthan High Court in SB Criminal Miscellaneous Bail Application number 16323/2023 at para
7, 8, and 9, my lord.
no para only as far as this point is concerned only para 7.
Okay, in para 7 from
Para 7.
para 7 till the next page, that is only relevant paragraph is only up to granted by coordinate bench of this court. Rule 2022, my lord. Para number 7
Yes.
till page number 5 in the first para of the rule 2022.
Till there, till that much.
Yes, yes, my lord.
Mengunung tu ada para 7 day. As observed as follows. I tanggal 2 ni 2022 more. The next contention of the Learned Council is that he was incarcerated in custody for almost 2 years, and for the delay in the trial, his personal liberty as guaranteed under Article 21 should not be trampled. Even if the rigors of Section 37 of the NDPS Act is applicable to his case, as has been submitted, having been in custody for a long period of time, the accused person in question may be enlarged on bail. The third contention put forth by the Learned Council is that the accused person in question has no criminal antecedent and having to take care of his wife and minor child may therefore be allowed to be enlarged on bail where any condition as deemed fit and proper to be imposed by this court.
My lord, in regards with the applicability of section 37, I have also...
That would not come into, into question.
Okay,
but since you your contention was, since the sample were drawn,
yes, my lord.
Yeah, which are of intermediate quantity.
Yes, my lord.
So intermediate quantity means section 37 will not be attracted.
Yes, my lord.
So if that is your your lack of contention, then it will be futile for you to argue on 37.
Yes,
otherwise, if you want to take defense on 37, then the other contention goes. Anything else?
Nothing else, my lord.
Per contra, Mr. H. Karmi, Leonard, additional PP, has strongly opposed the prayer made by the petitioner on the ground that records would show that the petitioner, that the accused person in question, went being one of the occupants of the said vehicle which was intercepted, from which the said 37 packets of contraband good, that is marijuana, have been seized, is very much aware of the presence of such contraband substance in the said vehicle. This was clearly indicated in his statement before the authorities, taken under section 67 of the NDPS Act. Accordingly, being in conscious possession of the said contraband substance, he may not be enlarged on bail on this count. As far as the delay in the trial is concerned, the Leonard additional PP has submitted that the charge sheet being filed on 2023 and charges framed on page 39, isn't it?
On 09/04/2024.
On 09/04/2024.
2024.
As was submitted by the Leonard Counsel for the petitioner, 3 of the 6 witnesses have already been examined and discharged. Accordingly, there is no question of delay in the trial, and this court may allow the trial to proceed in its normal course. As to the antecedent of the accused person in question, the Leonard additional PP has submitted that the investigating officer, the IO, during investigation has also obtained crucial information as regard the vehicle they were traveling in as much as it has been found out that the accused person and the other occupant were using a vehicle with a fake registration number, well, actually on investigation it was found that the said vehicle where is that
Page 21, Lodge. Page 21, last line.
the said vehicle is actually a vehicle registered in the state of Bihar with registration number BR01 BS 2941 belonging to one Shri Bikash Kumar, who has since sold the vehicle to one Shri Uttam Kumar. Therefore, under such circumstances, the antecedent of the accused person in question is doubtful. Therefore, it is the prayer of the learned additional PP that the prayer made in this petition may not be allowed. This court has given careful consideration to the submission made and has submission made on the contention of the counsel for the petitioner as regard the sampling, as regard the defective process carried out in course of taking samples of the said seized contraband substance, which initially were said to weigh about about 46 check the kgs, but from which but sample of which were taken from only 2 packets. The said 2 packet weighing about those are 20 kgs, 12 kgs, 2 kgs.
No, total weight is 47.
Therefore, on this ground alone, the prosecution may not be able.
Lordship, one correction. Total weight is 47.157 kg of the total, not 46. 147.
The last line. The prosecution .47. to sustain its case at the trial, and accordingly the accused person is entitled to be granted bail. This court would say that the case is still in the trial, the case is still under trial, with all the witnesses yet to be examined. Therefore, at this point of time, it may not be safe to come to any conclusion as to the strength or weakness of the prosecution case vis-a-vis the strength or weakness of the case of the defense, including the accused person in question. That is a matter to be left to the trial court, who would consider the body of evidence at the conclusion of the trial. It is to be reminded that even if the rigors of Section 37 of the Act is not to be taken into account in this particular case, yet bail is still within the discretionary realm of the court. As to the contention that the accused person in question has been incarcerated in custody for a prolonged period of time, if the period of 2 years or so is taken into account, the same may be true. However, taking into consideration the fact that the trial has proceeded in its normal course, no delay could be attributed to the trial court. As such, on this ground, the court is not inclined to allow the prayer of the petitioner. Thirdly, as regard the issue of antecedent of the accused person in question, it may be true that he has no criminal record so far, but that in itself would not qualify him to be enlarged on bail. even if this court choose to ignore the submission of the additional PP as regard the complicity of the accused person in question pertaining to the use of a vehicle with fake registration number, which would be a matter for the prosecution to pursue. Independently, the fact that the accused person is involved in a case relating to contraband substance, be it marijuana, heroin, or other dangerous substance, and also not being a resident of this state, as apparently from the record it is presumed that he is a resident of the state of Tripura. Therefore, the fact that he may be a flight risk cannot be ruled out. In view of the above observation, this court is not inclined to allow this petition. Seems disposed of. The same is accordingly rejected. On parting, it is requested, the trial court is requested to ensure that the trial is completed as expeditiously as possible. Yes, sir. Drugs case. Very sorry.
Item number 2.
In this matter, my lord, we have already filed the written submission, my lord. WPC 162 of 2015, my lord. I filed today.
But you have not advanced argument. Who you would argue, or Ms. Paul? Yes, Ms. Paul. Yes. Yes, I can hear you loud and clear.
I'm saying Lordship is pleased to take up the matter. I am ready.
You take it up. So, yes, before we take up this matter, we'll take up the other matter first in the order column.
Daily list, item number 1.
May it please your lordship. Your lordship, on the last date we had submitted that award had not been published in this matter. So your lordship, the question that had fallen was if the proceedings, land acquisition proceedings, had lapsed under the old act. So your lordship, we require some time because that aspect is still being examined at the moment, because some of the landowners have received compensation, your lordship, in this matter.
Basically, have the order dated 22/5. Because here, on the last occasion, counsel for has already made a submission, has admitted the fact that no award has been made in respect of the accusation proceedings. My lord, if no award has been made, that, my lord, in terms of section 11A, seems to be lapsed, since no award has been made within 2 years.
Now,
My lord, I understand.
she's saying that award has been made in some cases.
compensation has been paid and accepted by some of the
compensation
landowners,
has
Your
been paid
Lordship.
means what has
Yes,
been,
Your Lordship.
No, my lord. Your lordships, can you have my writ petition again? We may take your lordships to the RTI. At page 97. Annexure 14.
Annexure?
Annexure 14, my lord. Page 97.
Yes.
Well, here we have specifically asked the Revenue Department as to query number A, my lord, whether any award has been made passed in respect of the land acquisition proceedings for the construction of so and so. If yes, can you supply a copy of the award along with the list of the beneficiaries? Now, my lord, here the information provided by the Revenue Department. Land compensation was partially paid to the landowners, except for those where the verification report of claims and the counterclaims, the rightful owner is still awaited from the office of the BDO. My lord, here.
See, Mr. Sangwa.
My lord.
Okay, that's beside the point.
Yes.
It just struck me. See, these are, RTI query and RTI reply.
Yes.
What is the evidentiary value
Yes, Your Lordship.
of an RTI?
No, my lord, here, even before the reference
as far
code.
as, proceedings in court is concerned.
No, my lord, yeah, even the reference code. Well, the reference was made sometime in the year 2013.
We are not talking.
My lord, yeah.
We are not going to the facts.
My lord.
That is just I said it occurred to me. See, whether the court can take cognizance of such reply, whether it's an admission of fact,
Yes, Your
whether
Lordship.
it's a concession, of the like.
No, my lord, these are more or less because specific queries has been made. Now these are the answers provided by the department, indicating that
Whether
no
such,
precise answers
whether
have been
such
given.
answers can be carried to the court of law, as evidence.
As a reference, my lord, it can be taken into consideration.
I have not. You see,
I understand. Your
I have not had any cases of this kind.
My lord.
But that would be, some homework for you or food for thought.
Yes, Your Lordship.
You would be.
Your Lordship, here
you would be
I'm
more competent to look into this matter.
Because even our prayers, my lord, is typically we are asking either you pay us a compensation or if no award has been made, then the matter has been taken into afresh.
See, now we have to ascertain.
My lord.
Firstly, whether the award was made. If you are saying that compensation has already been given, means award has already been made. Perhaps not to your client, but to others. If it is, for the same project, then the question will be asked why some award has been given to, or compensation has been given to some, why it was not given to you. If you go by, I'm not so familiar with the new act, but if you go by the old act, in case there is a question of dispute, then Section 30 comes in.
Section 30 comes in.
So all those things has to be looked at.
Well, yes, that has been made already.
But then, if I understand correctly, as has been, considered by the government or the council, that if you are entitled to any compensation or any award for that matter, then it'll be given to you. Except for the fact that, like, again, come back to the same thing. If there is any dispute as far as title possession is concerned, that is a different thing.
That's a different issue.
Your Lordship, because here an amount had also been deposited with the reference court, which was returned to the collector. So, Your Lordship, we have to verify and see what has happened if that amount has been paid to the other landowners or not, Your Lordship. So, we require time just to verify those certain points, Your Lordship.
But you see, you have to be pointed.
Well,
see, you just have to see, as far as your query is concerned, you go through your records and find out
specifically
what is the the situation, or the status as regard the petitioner.
Yes, Your Lordship.
One petitioner?
Here, two petitioners.
Two petitioners, fine.
Yes, Your Lordship.
So as far as these two petitioners are concerned, you try to find out.
Yes, Your Lordship.
Don't
We have to
go
examine
others.
the
See,
records.
others have not come before this court.
Yes, Your Lordship.
They may not be aggrieved. So why would we take their case?
True.
Yes, Your Lordship.
Because if Your Lordships have already drawn your attention on the order dated 10/4/2019, my lord. If I may take again Your Lordship to the order dated 10/4/2019.
19.
My lord, this is passed by the. This is at page 90.
Yes.
Now, my lord, before that, can you Lordships turn to page 87? This is the reference made by the 87. This is the reference dated 3rd October 2013, made by the collector under section 18 of the whole act, my lord.
Yes.
Now, Your Lordship, kindly come to the order dated. My Lord, kindly have page 93.
Yes.
Para 9 onwards, my Lord. That for the instance, learned counsel so and so representing the heirs of J.J.M. Nichols Roy, whose name appear in the reference letter as interested person, submits that there are portion of land where there is no dispute, however, reference has been sent to this court. Similarly, in these para 10, 11, 12, 13, they have stated that there is no dispute. Now, my Lord, kindly have next page, para 16.
Yes.
It appears that the reference was made by the collector without identifying the dispute. Then, my Lord, the relevant provisions of law has been reproduced. Kindly have para 20, same page.
Yes.
A reference under section 18 is not for deciding the dispute between or among the interested person, but it is for determination of fair compensation. It appears that the collector has made a reference without examining the disputes. Though the reference was made under section 18A LA Act, but from the reference letter it is understood that it was made under section 30 of the LA Act. However, this court could not identify the disputes, the claim and counterclaim, which is sine qua non for a reference under section 30 LA Act. That from the reading of section 18 and section 30, it is understood that a reference in section 18 is made when any interested persons does not accept the award by written application. These are the things. Now, can you have the directions? That is page para 23. That is bottom. This reference is sent back to the collector, who will take necessary steps by identify the dispute, if it is with regard to the interests on the land or with regard to the determination of fair compensation. The reference being sent back shall not bar the collector from making fresh reference after identifying the terms of the reference. Now, pursuant to this order, the collector, the revenue department, that's the next page, page 96,
Yes.
has directed the BDO to conduct an inquiry.
This inquiry is ongoing, Your Lordship. It has not
Now,
been completed.
This was since the year 2021. Until date, the Lordships have also directed the state, yes, as to the status.
So that is so. See, their case is clear.
Yes, Your Lordship.
That as far as the petitioners are concerned, because the reference has been particularly made to them as
Yes,
as heirs of
my lord
certain person. So whether there is a dispute or not, that is for the the concerned authority to
determine, Your Lordship.
To find out. File a report. On the basis of the report, if there is no dispute, then the award is made.
My lord.
So we are stuck there now.
Yes, Your Lordship.
Now you are saying that inquiry is still going on.
Yes, Your Lordship. That's why, Your Lordship, we
Why would it take so long?
Order was passed in 2019.
Even if we take this, communication dated 25th
my lord,
August 96, page 96. So that is in
2021. That's what prompted us to file an RTI, my lord.
We've asked the concerned authorities, Your Lordship, to speed up with the inquiry also.
Please do that.
Yes, Your Lordship. We've advised them.
Finally, it comes to that. See, finally, what will happen?
No.
The court will give them the direction to them to do the needful.
Yes, Your Lordship.
So they will embark on the same exercise.
Yes, Your Lordship.
We'll wait for the response.
My lord.
Heard Mr. CCT Sangma for petitioner. Also heard Miss Seti Nukri learned GA appearing for the state respondent. Miss Nukri has submitted that these concerned authorities are still in the process of trying to trying to find out the status of the case of the petitioner as to whether any award has been given or whether any dispute is present as far as the land of the petitioners are concerned. In this regard, it is prayed that some more time may be allowed for such report to be filed, which in all probability would end the dispute at this stage. Accordingly, as prayed for, this is matter after 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Obliged, Your Lordship.
Second call from supplementary list, item number 2.
Lordship, two matters are listed together, Lordship. WPC 161 of 2015 and 162. 161, Your Lordship was already pleased to hear, and we've also filed a written argument.
Yes.
So today I'll be arguing 162, Your Lordship.
Yes.
Lordship. Lordship, these are those nip matters, Your Lordship, with regard to financial upgradation.
Yes.
But of course, each case is different in the sense that though it relates to financial upgradation, but the facts and issues involved are different in each case. So in this instant case, again, Your Lordship, the petitioner is a member of the non-teaching staff of the university. And as Your Lordship would perhaps recall, that these non-teaching staff, Your Lordship, there is no promotional avenue. And as such, to compensate for that, Your Lordship, some financial upgradation has been provided to such non-teaching staff. So the three which are the three financial upgradations which are offered to non-teaching staff, Your Lordship, usually there are first one is under OTM, which is a short form of one-time upward movement. Now this OTM happens after individual has served for 8 years, Your Lordship. After 8 years, he's entitled for this financial benefit under OTM, Your Lordship. Thereafter, what has happened in Lordship, the ACP has come into effect from 1999, and as per that, Your Lordship, on completion of 12 years and 24 years, financial upgradations are given. And again, subsequently, ACP has been replaced by the modified assured career progression scheme, and under that, which came into effect in 2009, Your Lordship, this benefit is given after every 10, 20, and 30 years. Now, in the instant case, Your Lordship, we have a limited grievance, Your Lordship. I am entitled to these three financial upgradations, Lordship. The first one is after completion of 8 years of service. After I get my first financial upgradation, 12 years thereafter, Your Lordship, which amounts to 20 years, I am entitled to my second financial upgradation. And on completion of 30 years in service, I am entitled to third financial upgradation. This is an admitted fact, Your Lordship. But in the instant case, admittedly, Your Lordship, only 2 upgradations have been given. That is, one is under OTM, and the other, the respondents claim that this is under the third NACP, that is after 30 years. So only these 2 upgradations have been given to me, and not the 3 upgradations I am entitled to. So that's my first contention. That of the 3 entitlements, I have only been given 2 financial upgradations. Now, my second contention, Your Lordship, is that the 2 upgradations which have been given to me also has never been given in time. And as such, I am claiming the said upgradation from whenever it is due to me. The two upgradations which have been given to me, Lordship, has been given to me at subsequent points of time after my date of entitlement. And as such, my prayer is, Lordship, that all the three upgradations be given to me, and the two that has been given, that also should be from the date when it is due to me, and not as has been given to me at a later date. Now I'll come to the factual matters of the case, Your Lordship. Lordship, the petitioner was initially appointed as a blacksmith in the Nagaland campus of Northeastern University. He was appointed on this date. Now this date becomes very relevant, Your Lordship. You will kindly note the date is 27/8/80. Lordship, we've also, it is before Your Lordship, a list of dates is also before Your Lordship.
Yes.
As a blacksmith. Now, thereafter, Your Lordship, what had happened in Nehu is certain posts were redesignated and it was called by a different name. Lordship, if I may just take Your Lordship to the relevant annexure in this regard. Lordship will kindly turn to annexure 2 at page 15 of my writ petition.
Page?
Lordship will kindly see that this page 15 annexure 2.
Yes.
If Your Lordship has got it.
Yes, yes.
Lordship has got it.
Yes, yes.
Annexure 2, page 15.
Yes.
Lordship will kindly see.
Can you hear me? Or
may I read this order, Lordship?
Miss Paul, can you hear me? Can you hear me? It's high time we all learn sign languages. I can't hear you.
Lordship.
Yes, sir. Now, can you hear me?
I can hear you, Lordship.
Fine.
Oblige you, Lordship.
Please continue.
Lordship, this order is dated October 1988. May I read, Lordship? The
Yes.
Vice Chancellor is pleased to order the redesignation in respect of the following posts in their own pay and grade with immediate effect. The qualifications and nature of duties will, however, remain unchanged. So number 1 is carpenter, which is redesignated as technical assistant carpentry. Number 2, which I am, Your Lordship, I was a blacksmith, that is redesignated as a technical assistant blacksmithing. So, Lordship, this post initially which I joined as blacksmith, this gets redesignated and it is termed as technical assistant, Lordship. And what I read earlier, Lordship will kindly note that these posts carry their own pay and grade. They carry their own pay and grade, and the qualifications and nature of duties also remain the same. So everything remains the same, only this is redesignated. The post is henceforth redesignated as technical assistant. So thereafter, Your Lordship, this post of blacksmith, Lordship, was having a pay scale of 1400, 2300, Lordship. If Your Lordship has the list of dates before Your Lordship, kindly note.
Yes.
So this post gets redesignated first of all, and in view of this designation, Lordship, my post also of blacksmith gets redesignated as technical assistant, and this post on redesignation earlier scale was 1400, 2300, Lordship. That is to 7,000.
Yes.
So Lordship I'm harping on this because Your Lordship, this is a redesignation of a particular post throughout. So there might be 10 blacksmiths or 10, 20 carpenters. So it is nothing personal to me only, Lordship. It is across the board in the university, all these posts are redesignated. And these are the scales which are given on the redesignation. So, Your Lordship, this is no upgradation given to me by any stretch of imagination. Lordship, have I made myself clear
Yes.
on this?
Yes. Yes.
So this redesignation is not an upgradation, Your Lordship, of it, or
Yes.
this is not a financial upgradation given to me.
Yes.
Now, Your Lordship will kindly note that this revised pay scale is from 24/11/88. But this revised pay scale, Lordship, has to be given from the date of joining, whenever the incumbent has joined. So in my case, it should have been 27/8/81. So that is my first contention, that this scale was wrongly given as from 24/11/88 instead of 27/8/81, and this is supported by the Register of NEMU in a subsequent document which I'll take your Lordship. So what I'm laying stress on is the fact, Lordship, that this is a redesignation and it is not giving of any financial upgradation to the petition. Lordship, I get my first financial upgradation under autumn. Lordship will kindly remember, autumn is to be given after completion of 8 years. That is the rule. So if autumn is to be given to me, Lordship, I joined in 1981. So I am entitled to autumn in 1989. Or if I joined on 27/8/81, Lordship, after 8 years, I am entitled on 27/8/1989. I am entitled to get autumn, Lordship. But this was not given to me in 1981. The autumn was given to me, Lordship, by order dated 29/9/2001 with effect from 24/11/96. Lordship, that is in my list of dates. That's the next under 29/9/2001. This is my first upgradation, Lordship.
So here your scale was upgraded from 4500.
Lordship, here my scale is upgraded from 4500 to 7,000 to
Yes.
5,500, 9,000.
Yes. Yes.
This is my first upgradation, Lordship. Under autumn.
Yes.
Here, Lordship, 2 points. First, autumn should have been given in 89 to me when it became due. But Lordship will kindly note, by order dated 29/9/2001, it is given with effect from 24/11/96. So they are giving me this first benefit only after 15 years. So my first upgradation under autumn is given to me after 15 years, Lordship. When my pay scale is raised from
See,
4,500 to 2,000.
Miss Paul, as far as that autumn is concerned, is it mandatory?
Lordship, I am entitled, yes, Lordship.
Okay.
Lordship, and they also call it autumn. So when they are giving it to me after 15 years, Lordship, they are giving me this upgradation under autumn. This is a one-time upward movement.
True.
So the university is giving me this benefit of the first financial upgradation under autumn only. So there's no denying that I am entitled to autumn, Lordship. This they are not denying. Only they are giving to me at a subsequent date. So my contention, Lordship, here is that this autumn should have been given to me from 27/8/89 when it was due to me. So now Lordship will kindly note that this was the first financial accreditation given. Now thereafter, Lordship, the ACP scheme, the Assured Career Progression Scheme, comes into effect in August 1999. And under this scheme, as I mentioned, Lordship, that after 12 years and 24 years, petitioner becomes entitled. So I am entitled to my second financial upgradation, Your Lordship. But in my case, Your Lordship, no second financial upgradation has been given at all, admittedly, and only when the MSCP scheme, which comes into effect from 2009, Your Lordship, that's when they give me my third MSCP. They say it is third MSCP, Your Lordship, but that is actually my Lordship. This MSCP is given on 7/7/2014.
Yes.
So this is given with effect from 27/8/2011.
Yes.
Now, Lordship, this they are calling the third MSCP. That is the third upgradation.
Yes.
Now, admittedly, Lordship, I have only got autumn. I have not got anything else after that.
Yes.
No ACP. This is an admitted position, no ACP. And this financial upgradation which they are giving on 7/7/14, Lordship, that actually is the second upgradation, but they are calling it the third. So, my contention, Your Lordship, is that I have been denied of the 3 financial upgradations, and only 2 has been given. As I pointed out, one under autumn, which has been given after 15 years, and this which has been given in 2014, Your Lordship, again, long after when it is due to. So, this I've left in the second page of this list of dates, Your Lordship. This just for Your Lordship's convenience, Your Lordship.
Yes, sir.
These are the 2 financial upgradations which have been given. On 29/9/2001, petitioner was given his first financial upgradation under autumn by order dated 29/2001, and his pay scale was upgraded to 5,500, 9,000 with effect from 24/11/96. And next page, Your Lordship, the second upgradation has been given.
Yes.
Is this what they claim to be under third MSCP, dated 7/7/2014.
Yes.
So these are the 2 which has been given. Now, what has not been given to me, Your Lordship, what is due unto me is in the next column, the 3 financial upgradations which is due to me, Your Lordship. So my first contention is that the first autumn which was given should have been given after 8 years of service was given after 15 years, Lordship. So what is due to me is, Lordship, the autumn after 8 years in the pay scale of 6,500, 9,000 with effect from 27/1/89, Your Lordship.
Yes.
Sorry, 27/8/89. Sorry, this is a pending error, Your Lordship. 8/89. Am I clear, Your
Yes.
Lordship?
Yes. Fine. So.
First autumn given to me after 8 years, 15 years should have been after 8 years. So from that particular date, I was entitled to that raise, Your Lordship, of first financial upgradation of 6,500, 9,000, which has not been given.
But you were given 5/5. Where is it? Yes, you were given 5,500 to 9,000.
Not.
But where does this 6,500 comes from?
I'm coming to that, Your Lordship. I'm coming to that. Lordship, may I just complete this part? Then I'm coming to the recommendation of the registrar himself.
Okay.
Since your Lordship has posed a query, Lordship, I'll just take your Lordship to the relevant document. Lordship, may kindly turn to Annexure 5, page 24.
Yes.
Lordship, this is a recommendation of the registrar of the Northeastern Hill University. Lordship, you can kindly see it at the bottom of the page. This is a signature of the registrar. Nehu.
Yes.
Lordship, kindly see his comment, your Lordship. This is with regard to the petitioner, your Lordship, NR part.
Yes.
These are his individual details, your Lordship. What I just argued is all here, your Lordship.
Okay.
But I may just take your Lordship quickly through the columns. Lordship, after the sixth column, there this name of the post, scale, pay, date of joining, whether direct recruitment or promotion. If your Lordship has got it. Under the sixth item.
Yeah. Name of the post, yeah. Yes, yes. 6.
So name of the post, your Lordship, is blacksmith.
Yes.
Scale, then date of joining is 27/8/81.
Yes.
And direct recruitment, Lordship. So, Lordship, thereafter, Lordship, this scale of pay actually is, Lordship, 1400, 2300, which your Lordship will see in the next column.
Yes.
So, when the post gets redesignated as technical, from blacksmith, when it becomes technical assistant, Lordship.
Yes.
Lordship will kindly see that it is redesignated on 24/11/88.
Yes.
Am I clear, your Lordship?
Yes, yes.
Then the next column is autumn, Lordship.
Yes.
Then under autumn, Lordship, I am given 5,500, 9,000, which I have just argued, Lordship.
Okay.
And that is given to me on 24/11/96. And it is it is repeated autumn. So they are clearly admitting that under autumn they have given me this first financial accreditation, Lordship. So, Lordship, here I come now to the bottom of the page, your Lordship.
Yes.
Because your Lordship had posed a query from where the 6,500, 10,500 is coming. Lordship, this is the recommendation of the registrar. He says he is entitled to receive autumn in the scale of 2,000, 3,500, that is equivalent to 6,500, 10,500, with effect from 27/8/89.
Yes.
Which I am saying, Lordship.
Okay.
As the STS, that is the senior technical assistants who joined up to 8/4/98, were given the scale of 6,500, 10,500.
Yes.
Instead of 5,500, 9,000. So, Lordship, because all the other technical assistants serving in the post were given this 6,500, 10,500, and the registrar himself admits that wrongly it was not given to me.
Yes.
It clearly says, Lordship, which was wrongly given to Sri N.R. Pal with effect from 12/11/96. So the registrar name clearly admits that only to me this 5,500, 9,000 was given wrongly, whereas all the others technical assistants who joined prior to 1998 was given the scale of 6,500, 10,500. So in view of that, Lordship, my claim is that I should be given 6,500, 10,500 with effect from 1989 when it became due to me after completion of 8 years.
See, Ms. Paul, when when this noting of the registrar, is there, when was this given? Which date?
This is dated 26/8/2009.
Yes. So after this, let's say recommendation, was your pay scale revised or it remains the same? That
no,
five.
After that, Lordship,
Was this 5500 was not revised?
No, it was not revised.
Okay.
I continue to get the 5,500, 9,000.
Okay.
Lordship, this last line of his recommendation is also important. He also says that he is also eligible to get second financial upgradation under ACP in the scale of so-and-so from so-and-so.
Exactly.
Because my next contention is that, Lordship, I have never been given a second financial upgradation.
Yes.
So this recommendation is there from the registrar himself saying that I am also entitled to the second financial upgradation and to what scale and from which date is also mentioned. So when I was reading this, my list of dates, Lordship, the second contention was this, Lordship, that when the petitioner is due to get the second financial upgradation, this is in the last page,
yes.
second last. What I have not got, Lordship, what I am due to get. The petitioner was due to get second financial upgradation under ACP scheme after completion of 12 years of service in the pay scale of so-and-so. So this is also recommended by the registrar here, Lordship.
Here it says 2001. You asked for 2001. Register says 2005.
Lordship, that it's his recommendation, but Lordship, because it is a clear calculation.
Yes.
The calculation is 8 years autumn and after that 12 years.
Okay.
So basically 20 years, Your Lordship. So if I have joined in 1981, it's a clear calculation, Lordship. 81, 91, 2001. 20 years in 2001, it becomes due to me, Your Lordship.
Okay.
It's a clear calculation. So when I completed 20 years, I should have been given this second financial upgradation and as given under the ACP scheme, not given to me, admitted to me. So my prayer before Your Lordship is that this should be given to me, Your Lordship. And the third is that, Lordship, the MACP, the third, Lordship will kindly note what they have given to me is a third MACP, and that has been given in 7/7/14 with effect from 27/8/2011.
Seven 14. Yes.
Lordship, it is the date of the order is 7/7/14, but the benefit is given with effect from 27/8/11.
Okay.
Now they consider this as a third upgradation, Lordship. But Lordship will kindly see from the facts there is no second upgradation. So my contention is that this third MACP should have been given to me, which I mentioned, Lordship, on 27/8/2011, was due to get the third financial upgradation under MACP scheme after completion of 30 years of service in the scale as given by the 6 CPC with effect from 27/8/11. Again, a clear calculation, 81, 91, 2001, 2011, Lordship. I joined in 81. So
yes.
After 30 years on 27/8/2011, I am entitled to the third MACP, Lordship. Whereas Your Lordship will kindly note that they have given to me only on 7/7/14, not in 2011, and they have given a scale which is lower than what I am entitled to, Lordship. I am entitled to under this 6 CPC, the grade case 6,600. What has been given to me, Lordship, is a lower grade that is 4,600. So this is my limited prayer, Lordship, that these three upgradations, two which was given but not in time, and the one that is not given, so all three should be given, and the corresponding pay scales will follow. So that in brief is my case, Your Lordship.
Fine. Have you cited any precedent where some of your colleagues in the same cadre must have received first autumn, then second ACP and MACPs? Or this treatment has been meted out to all? Something's wrong.
Lordship, I was disconnected for a little
No,
while. So
okay.
did not
No, my question is this: have you, or rather, are you able to cite any, case or any precedent where some of your colleagues in the same cadre has been, given the autumn, second ACP and MACP at certain points of time, or they were all given, in same manner as was given to you?
Lordship, I can place that. I can try and place that, Your Lordship. But I will need a little time to get the.
Because you see that,
Otherwise,
that would strengthen your case or, defeat your case.
Lordship, in this regard, may I humbly submit, Your Lordship, that these three entitlements, Lordship, I have just.
No, I understand. I understand. What you have stated is, going by the law, so to say. All the rules, all the rules. But what I'm saying is that if you want to strengthen your case, you cite precedent and see. Or if it is a standard, if it is a standard approach of the authorities to all concerned, as far as your cadre is concerned, then perhaps there must be some explanation.
Lordship, what is pertinent is also the other connected matter which has come in this
161.
Number 161.
Okay.
Item number 161.
Same situation.
No, it is not. Here again, Lordship, again, 3 benefits to be given, but 2 different benefits given, 1 not given.
Okay.
In the other one, Your Lordship, autumn not given. After my learned friend replies, I can also take Your Lordship for a comparative appraisal of both the matters. I've also placed a written argument in that also, but I can brief Your Lordship quickly on what are the difference between this case and that case. After my learned friend replies.
Yes.
May it please, Your Lordships. Your Lordship, my lords, now admittedly, my lord, 3 schemes are involved here. One is autumn, one is SCP. Now, my lord, autumn was holding field till the month of August 1999. From August 99, this is being replaced by a new scheme which is called, my lord, Assured Career Progression Scheme. Now, these hold the field, my lord, till 2008 when MSCP replaced it. This is the situation. Now, my lord, if you look into the schemes, Your Lordship, I'll take my lord to the relevant part. What the scheme contemplated, these are meant for, Your Lordship, will keep it in mind, these are meant for central government employees. Central government employees, Your Lordship.
Yes, sir. Whether you able to hear? You hear him?
Lordship, I can hear.
Yes. So, my lord, yes. Okay. So, my lord, these are the 3 schemes. So, what are the intention or objective of these schemes? That any government servant, my lord, facing stagnation, they would be, after the coming into force of the MSCP with effect from August 2009, and which is still holding the field, then a government employee facing stagnation would be entitled to 3 financial upgradation in his entire career, not more than that. Now, my lord, subject to certain conditions. Conditions are these, that if already in the career he or she has already granted a financial upgradation, that is to be adjusted. This is very important, Your Lord. That is to be adjusted. Suppose SCP say 2. Now, if already 1 financial upgradation has been granted to the employee before SCP has come into force, then he or she is not entitled, my lord, for 2 more financial upgradation. Then only 1. And this is the thing. Now, my lord, secondly, my lord, these schemes are, my lord, meant for designed for central government employees. Now, we are university, my lord, we are not central government employees. We are statutory bodies, my lord, central universities. Now, these are required to be extended to the university subject to such condition by the UGC, University Grant Commission, which are the sponsoring authority, my lord. They will look into the scheme, examine the scheme, take it up with the MHRD. Then they, by a formal order, they will extend it to the university subject to their conditions. Now, we cannot ignore their conditions. These are binding on us. Now, my lord, if I can take your lordship into their writ petition, when MSCP came into force in 2009, immediately we did not follow it because we are not supposed to follow it unless it is extended. Ultimately, it was extended, my lord, by a letter, my lord, communication. That is, my lord, at page. I'll take my lord to that letter. That is at page 35, Annex 8, dated 9 July 2010. If I read out this letter, this clarify everything, my lord. 9 July 2010, my lord, this is addressed to the registered Northeast Technical University. This is from UGC. Yes. Extension of modified assured progression scheme MSCPs to the non-teaching employees of the Central University, etc. etc. The Government of India, Ministry, Personnel, Public Grievance, Pension Departments, Training, etc. etc. notified OM dated such and such. The Ministry of Human Resource Development, Department of Higher Education, in consultation with the Ministry of Finance, Department of Expenditure through its Integrated Finance Division, has conveyed the approval of the Government of India by letter dated 7/4 to extension of MSCPs to the non-teaching employees of Central University, Inter-University Center institution deemed to be universities funded by the central government through UGCs. The Ministry by its letter, even number dated such and such, further clarified and has issued modification in certain conditions contained in the letter dated 7/4. In view of the above, UGC extend MSCP scheme to the non-teaching employees of central universities. That means NEHU is a central university, my lord. UGC maintain deemed university, UGC maintain colleges affiliated to central university, colleges, Allahabad University, subject, lordship will take note, subject to the following conditions. Now they have clarified these conditions. This is binding on us. Number one, where the ACP scheme was applicable in this institution, the institution concerned must switch over to MSCPs. Number two, where the earlier scheme, if any, adopted by the various institutions was different, my lord, that's not very relevant for this case. Next, number three, adoption of MSCPs by the institution concerned will be subject to the approval of the executive committee, etc. This has been approved, my lord, by the executive. Four, under MSCPs, there will be placement, immediate index, my lord. This is the mode of selection and all, my lord, I can skip. Then 5, MSCPs will not be admissible if an employee has already earned 3 promotions, either by way of regular promotion or SCP schemes. My lord, these promotion referring to financial upgradation. They are clarifying that if under any circumstances, not under any scheme, this can be, I'll come to it, by way of redesignation, my lord, cadre restructuring, it is possible. If the employee of his own also grant a financial upgradation, that has to be counted. Now, this is clearly spelled out, my lord, in the next clause, clause 6, very clearly spelled out. It is to be ensured, lordship will see the language, yes, that in case any promotion, personal promotion, time-bound promotion, one upward movement, they have mentioned to this, my lord, OTM, second upward movement, in situ promotions, any upgradations, they are saying any upgradations, any club structuring scheme, personal pay scale schemes, any restructuring of cadres, I'll just stop here, my lord, restructuring of cadre, my lord, redesignation, that amounts to, my lord, this is a part of exercise of restructuring of the cadres. While the cadre, there exists a post of technical assistant blacksmith. Now that has been redesignated, my lord, subsequently as technical assistant blacksmithy. This is part of exercise of cadre restructuring. This redesignation by way of cadre restructuring. Restructuring of cadre, implementation of local cadre review committee recommendation, any large scale mass stepping up exercise. This is also, they are saying, employer of its own, if there is a mass stepping up, upgradation, etc. carried out by the universities in the past, before 8/4/98 and thereafter, the financial upgradation was And thereafter, financial upgradation was awarded under SAP scheme 19, if any, resulting into financial benefit of higher pay scale have to be adjusted against the MSCP scheme. So all these are to be, my lord, if already granted, my lord, under this situation, my lord, including, my lord, cadre restructuring, which redesignation is a part, then plus, my lord, if any granted under SCP, then these are to be adjusted against what is provided in the MSCP. Now, what has been provided under MSCP? 3 financial upgradation, my lord, altogether in the careers. Now you will take, my lord, what he has been given. If I can take, my lord, I made it for your convenience of your lordships in my written argument, my lord. If your lordship come to last but one page, my lord, of my written argument. I have sat out a table.
Page.
Oh, sorry, my lord. I think I will do the paginations for your lordship.
Page
Last
5.
but one, my lord.
Page 6, page 5.
The table, lordship has got the
Yes,
table. Yes, my lord. Now, if your lordship looks, my lord, the brief summary, my lord, what he has availed. N.R. Paul, date of birth is, now he joined, my lord. He joined in as a blacksmith, my lord, in the year 81, my lord, at the pay scale of 263.50, very less. That was under third pay commission. That was under third pay commission. Lordship will leads to the corresponding revised pay scale under fifth pay commission. This 263.50 became 3050 to 4590.
Yes.
My lord, under fifth CPC. Now these were under third CPC, my lord. Now, if your lordships come to the last column, benefit avail.
Yes.
He has been redesignated as technical assistant, blacksmithing,
Yes.
by an order dated, my lord, 88. I'll take my lord to that order. It happened in 88. But 88 orders say, initially on redesignation, they say, on the same grade and the same pay scale. They had not granted him higher pay scale, 88. But subsequently, my lord, in the year 2008, they passed an order, Nehru passed an order, treating that on redesignation, you will be placed on the next higher pay scale. Then what was the next higher pay scale under fifth? In the bottom, I have mentioned, my lord, next 4,500 to 7,000. My lord. Otherwise, my lord, his pay scale would have been, my lord, 3050 to 4590. But instead of this, my lord, we have placed him in the next higher grade of pay, that is 4,500 to 7,000. Now, if I can take, my lord, that order is in the writ petition. Kindly come to that order. There is Annexure 3, my lord. Redesignation was done, my learned friend, senior friend has read it out, my lord, Annexure 2. No upgradation was granted when the redesignation was initially done in the year 88. But in the next page, my lord, page 3.
Yes.
This is an order passed into. In pursuance of the notification dated such and such, the Vice Chancellor Shillong is pleased to fix the pay of Nikhil Ranjan Pras technical blacksmith with effect from 1980 in a course pay scale of 1,200 received, 4,000 revised to 4,000 to 7,000. This is given with effect from 24/11/88, and and thereafter by the same order, one upward movement of pay scale of such and such which amount to 5,500 to 9,000. By the same order, my lord, he was granted a financial upgradation, my lord, on redesignation with effect from 88, and further he was granted one upward movement. One upward movement under the OTUM, that means which he is entitled only after completion of 8 years of service from the last upgradation. Now, last upgradation happened, my lord, in the year, my lord, September 1988 happened. Now, if your lordship count 8 years, then it becomes due on, my lord, September 1996. The next financial upgradation. Now, your lordship, if I can take my lord further, now your lordship will come 24/11/96.
Where is that?
24, just below this, my lord, where they have set out the figures. 24/11/88. Yes.
88.
Yes, my lord. Lordship has got it. 24.
Yes.
Yes. Lordship will come to the, my lord, on the right hand side. Now he has been placed into the pay scale of 5,500 to 9,000.
Yes.
And what is his pay scale which he has been granted from 25/11/96 become 5,500. So that became effective. This is not in dispute. From 1996, what my learned friend is arguing that this OTUM should have been granted to him with effect from September 88 because he joined his service 81. She's what learned friend is 89. So on completion of 8 years, which is perhaps my lord 1989, he should have been granted one upward movement. Well, this is wrong. It cannot be because by way of redesignation in the year 1981, he was already granted a financial upgradations, my lord, and he becomes eligible for second financial upgradation under OTUM, one-time upward movement, on completion of 8 years from the last financial upgradation. That is happened in September 88. So it became due in September 96. So that was also given. So with this, my lord, 2 financial upgradation in his career he had availed. Now again I take my lord to the same table. Same table, my lord. Yes. On the right hand side, OTUM, my lord, we have mentioned about placement on redesignation, my lord, to higher pay scale of 4,500 to 7,000 with effect from 24/11/80 under OTUM. Then under OTUM, my lord, we placed him to the next higher pay scale of 5,500 to 9,000 with effect from 24/11/1996. 24/11/1996.
Where is it?
My lord, in the table, the same table of my written argument. Of my written argument.
Yes. Oh, an argument?
In the written, my written argument.
Okay.
So on OTUM,
1996.
yes, he has been placed, he has been granted the second financial upgradation, my lord. This is to be counted as second financial 24/11/96. Now after, my lord, MSCP came into force, my lord, which say in entire career he is entitled for 3 financial upgradations. So, my lord, since 2 had been granted, only 1 remain available, my lord. And the last third financial upgradation, my lord, he is entitled on completion of 30 years. Now he joined service in 81 and he has been given the MSCP, which is treated as third financial upgradation, my lord, with effect from 27/8/2011, my lord, when he completed, my lord, 30 years of service. He completed 30 years of service on 27/8/2011. On completion of 30 years of service, my lord, he was granted his third financial upgradations. So, my lord, my humble submission, my lord, he has been granted all the 3 financial upgradations. Now, entire confusion is here created, my lord. Once your lordship understand what is this redesignation and whether on redesignation he has been granted higher financial benefits, my lord, financial upgradation, my lord, that clears everything. Because my learned senior friend, she is not disputing the fact that under OTUM, she was granted, my lord, financial upgradation. But only confusion is here, my lord, that redesignation and granting of financial upgradations, my lord, requires to be counted.
But this language here, see that redesignation,
Lordship,
that October 1988,
Lordship,
it says in their own pay
exactly
and grade.
Exactly, my lord.
Oh.
But that has been corrected subsequently. That is why, my lord, I have taken, initially it was own grade. Had it been like this, my lord, own grade and pay, there is no financial upgradation. What the UGC's letter say, if the redesignation or cadre re-exercise resulted into financial upgradation. Now, by this letter, it has not resulted into financial upgradations. True, same grade and same pay. Come to 81, next page, my lord, Annexure 3.
Okay.
Annexure 3. That is passed subsequently in 2000. In pursuant to the notification such and such, Vice Chancellor Shillong is pleased to fix the pay of Sri Nikhil Ranjan pay with effect from entry in the post pay scale of such and such revised pay scale 4,500 to 7,000. So here, my lord, comes the financial benefit resulted in financial upgradations. And by the same order, and 1 upward movement the pay scale to such and such. So by this same order, my lord,
same order is getting 2 financial benefits.
2 financial on redesignation initially on the same terms, my lord, same pay grade. But by this, we have placed him in the next higher, first part of the order, we placed him in the next higher pay scale with effect from 88. Secondly, my lord, on completion of 8 years, we granted him one time upward movement to next higher pay scale with effect from 96 on completion of 8 years. So by this order, we had granted him 2 financial orders. One by way of redesignation with effect from 88 and one on completion of 8 years from the last financial upgradation, that is with effect from September 96. So having granted 2 financial upgradation, my lord, after MSCP came into fix, what remained due to him? Only the 3rd financial upgradation, which he is entitled on completion of 30 years. And he completed 30 years, my lord, in the year 2011, and we have granted him. Yeah. Now, my lords, my learned friend senior friend, also referred to the letter of the, my lord, some notings by the register, my lord. I'll take my lord to that. Annexure 5. This is not a recommendation. Even a recommendation cannot bind the university, my lord. There can be a suggestion, there can be a, my lord, notings. That cannot bind the, we'll have to go by the, this has happened in 2005. 2005, that UGC, my lord, letter was not there. UGC letter was very clear and categorical. They said you ensure that you implement it subject to the condition we are laying down. We'll have to adjust. If there is any financial upgradation by way of greater restructuring, much stepping up, these are to be adjusted. Now, this, if your lordship, Annexure 5 on the top, individual employees detailed for consideration under SCP scheme. Simply a format has been prepared by the register. This is not even a recommendations. Now, my lord, come to the bottom. His notes. Yes. He is entitled to receive OTM in the scale of such and such with effect of such as STS, Senior Technical Assistant. Altogether a different cadre, my lord. Senior, he is a technical assistant blacksmithing. Now a comparison is been drawn with a senior technical assistant. Absolutely, my lord, misconceive this. This is only a notice. This cannot bind the university. And anyway, your lordship, we cannot go against the condition laid in by the UGC. So my humble submission, my lord, other thing, what are the papers, what are the relevant papers?
So you mean to say that on this, see, this may have been a recommendation.
This is not a recommendation.
No, but whatever the case is,
it's a note.
It's a noting by the registrar.
Noting by registrar.
Registrar is, you see, he is one of very important authority in the university. No. What was the decision taken? Was it considered? My lord, was it discarded? No. Was it accepted?
My lord, this cannot, because this, you see, in the meantime, what happened, your lordship? Because these are, in the meantime, what happened? This is in 2005. After that, what happened, my lord? MSCP came, and MSCP was extended to the university by UGC.
No, Mr. Sen, I'm not talking about.
Lordship.
I'm just, you see, we are taking this in isolation.
My lord, what do you have?
Taking this recommendation in isolation.
Just a second. I'll just try to find out, my lord. What is the reply to paragraph 5? Reply to paragraph 5. I'll just read it, my lord. This is in their paragraph 5. We have filed our affidavit. In our affidavit, my lord, paragraph 7, we have taken our stand. Lordship has got it.
Page 7.
Paragraph 7, at page 7.
Yes.
I just read it, man. That with regard to the statement made in paragraph 5 of the writ petition, the answering respondent denies the same as, right? It is stated that the answering respondent, the writ petitioner, was recruited as blacksmith in the respondent university in the core pay scale of such and such in 81. The first financial upgradation OTM scheme has been the pay scale of 4,000 on completion of 8 years of service. However, the respondent university very leniently pays the writ petitioner in the pay scale of 4,500 on redesignations. Well, even you would have lost out. What my learned senior friend is asking, you should have given him on completion from 88 or 89 in the next higher pay scale. It would have been next higher pay scale would have been only 4,000 to 6,000. Place the writ petitioner pay scale 4,000 on redesignation before completion of 8 years of service and thereafter granted OTM benefit in the pay scale of 5,500 to 9,000. That's what we are saying. The two benefit has been granted. It is further stated by the answering respondent that the academic qualification required for the post of blacksmith technical assistant and senior technical assistant is quite distinct and different. That is what the, my lord, what the noting say, that since the senior technical, altogether a different thing. So this stand we have taken, my lord. Technical and senior is quite distinct and different. Similarly, all these positions carry different core pay scale as well as job requirement. These are totally distinct posts, different responsibilities. None of the technical assistant who has joined the core pay scale of 4,000 to 7,000 was granted the pay scale. We have denied specifically. I mean, this is wrong. 6,500 to 10,500. Nobody has been. Right? Lordship was inquiring. Similarly situated person granted. They have categorically denied, my lord. This is not correct. What the register tried to, my lord, make a comparison with the senior technical assistant. On completion of 8 years service under the scheme. The case of the writ petitioner is different. The writ petitioner was recruited as blacksmith in much lower pay scale, thereafter under the cadre of restructuring exercise. We are mentioning this is part of the cadre restructuring exercise undertaken by the Reach University. Pay scale of such and such was granted on resignation of the post of blacksmith as technical assistant. Whereas the senior technical assistants who were recruited in the scale of rupees 5,900 prior to 95 were placed with a pay scale of 6,500 to 10,500. The other category of senior technical assistants who were recruited prior to this with the core pay scale were granted the pay scale of such on completion of 12 year service under the strict compliance with. Further, the employee details and proposal therein in an internal document which cannot be constituted as a final document duly approved by the University Grant Commissions, Government of India in deviation from the original OTM SCP scheme. The office complied with this information in respect of all the non-teaching employees for submission of the University Grant Commission as desired by the Commission, which was not approved by the University Grant Commission. Moreover, the University Grant Commission directive and communication along with the copy of the letter dated such and such of the Nehru University attached to the post such and such. So, my lord, this is nothing, my lord, a format fill up by the register for considerations. So these we have taken note and found that this is not appropriate. And obviously not appropriate. We could not have drawn comparison with the senior technical assistant, different cadre, higher pay scale. So my humble submission, my lord, by way of redesignation, granted one. Next, OTUM we have granted. On completion of 30 years when MSCP was holding, we have granted. So nothing remains, my lord. So all has been granted, he is not entitled. As regarding, my lord, the relevant documents and other thing, my lord, I have clearly mentioned in my written argument, those relevant pages, what are the orders, what are the next higher pay scale, all these things are referred to in my written argument. So my humble submission, this is a case, my lord, call for no interference. And if I am not, I think they have already, since long they have retired also.
Yes, yes. They have retired. Who doesn't want more money?
More money. But if they are entitled. And other thing also, UGC is not even a party. Can we, and that challenge, 2010, which is very clear and categorical, if they agree, they should have challenged that re-resignation, upgradation should not have been counted. They should have challenged that UGC letter. This UGC letter is not under challenge. And Lordship cannot ask the deviate from UGC letter. That is binding on us. So my humble submission, it doesn't call for any interference.
Lordship, here the three words which are of relevance is, one is redesignation, Your Lordship, and the other is upgradation, and the third, which my learned friend keeps on referring to every now and then, is the upgradation, the revision given under the different pay scales. We are dealing with three different things, Lordship. Lordship, when we're talking of revision of pay scales, Lordship will kindly appreciate every time there is we are talking about the 5th pay commission recommendation. There's a recommendation by a pay commission, Lordship.
Yes.
On that basis, Lordship, across the board, throughout India, anyone holding a certain post, whatever is the revised pay scale, that person becomes entitled, Lordship. Am I clear, Your Lordship? every time there is a pay commission recommendation, there is a revision of pay scale. So we have the 5th CPC and we have the 6th CPC. So as per that, scales are revised across the board. It is not in relation to a particular individual. It is across the board. Whenever pay revision is happening, it is across the board. Now, if every time a revision happens and some kind of pay scale revision, meaning financial benefit occurs to the petitioner, not if that cannot be termed as a financial upgradation, which Nehu has time and again tried to say that if you've got some revision under your pay scale has been revised and you've got something more than what you were getting earlier, that is also some financial benefit, so it is an upgradation.
Well, you mean to say that, just a moment, you mean to say that, you see, this 4500 to 7000, when it was, when the same became 5500 to 9000, it was on account of the on account of the pay revision. It was the six pay commission revision. Whatever.
Technical assistant, which was earlier known as.
Yes, true.
What I was trying to differentiate, one is the revision. Every time a pay revision happens,
true.
across the board there is financial benefit.
Yes,
so that financial benefit cannot be taken to be a financial upgradation
That's
as contemplated by OTAP, ACP and MACP.
That's understood.
It's a totally different. It's particular to an individual, the financial upgradation. But pay revision is across the board. Whenever it happens, everybody gets some benefit. Now, if I get a benefit under revision logic, can that be taken as you've already got some benefit? So now I'm going to cut out your 3, I'm not going to give you a 3. You've already got some benefit, so no, you will not get your 3. That logic cannot apply, Lordship. So, Lordship will, as if I may again go back to that document which I have also referred and my learned friend has also referred, Your Lordship. Annexure 2 and 3, Your Lordship. Annexure 2, Your Lordship, as a Lordship has kindly noted that when this redesignation took place of all these different posts, Lordship.
Yes.
It is not only restricted to blacksmith, it is carpenter, blacksmith, mechanic, welder. They are all have been redesignated as technical assistant, Your Lordship. So they are carrying their own pay and grade and responsibilities and qualifications, nature of duties, Lordship. Now, Lordship, after that, the next document, Annexure 3, page 16, which my learned friend was trying to read it as an upgradation, Lordship, it is not an upgradation. May I read this again, Your Lordship?
Yes.
This is order dated 29/9/2001. In pursuance of the notification number so-and-so dated 16/8/2001, the Vice Chancellor Nehu Shillong is pleased to fix the pay of Nikhil Ranjan Paul, Technical Assistant Blacksmithy with effect from 24/11/88 in the core pay scale of 1400, 2300, revised to 4500, 7000. This is a revision, Your Lordship. This is not an upgradation. It is revised as per pay scale across the board. Am I clear, Your Lordship?
That is why I was That is why I was asking. That is why I was asking you. If it was revised to 4500, this is in consonance. Okay, this is in consonance with the pay commission revision recommendation.
Lordship. So when the post was redesignated, this was the revised pay scale given to that post.
Okay.
Of the technical assistant, Your Lordship.
True.
And then the next line, Lordship. Then comes and on the upwards pay scale of pay under so-and-so, revised to 5,500, 9,000 as here. This is my upward, Lordship. This is my only upgradation, Your Lordship. The second one.
Yes.
5,500, 9,000 is the upgradation, Lordship. Where is the first one is 4,500, 7,000 is a revision of pay, Lordship. So there is a gulf of difference between revision and upgradation.
Yes.
And as a Lordship, we will try and produce a document to establish this fact, Lordship, that all the others serving in that particular cadre, their pay was also revised to so and so. Not necessarily everybody got upgradation, Lordship. But revision will be across the board. Anybody serving in that particular post, if the scale is revised, Lordship, this benefit will accrue to them.
Exactly. See, like you said, Miss. See, like you said, revision would be across the board. Upgradation would be personal.
Absolutely, Lordship. Obliged, Lordship.
No, my lord,
And
only
Lordship,
that
this
couple.
is just one point, just to page 24, Your Lordship. My learned friend is saying that this is an upgradation. This is a recommendation by the
Give me the written argument.
registrar, and they are not bound by it. Page 24 in each of 5.
Yes, yes.
The recommendation, they are not bound by it. Even if we buy that argument for some time, Your Lordship, the facts do not change, which is in this document, Your Lordship. Now, Lordship will kindly see, this is on top, it is written the individual employee details for consideration under ACP scheme. This is a document which has not been prepared by me. It has been prepared by NEHU. And registrar is the representative of the university, Your Lordship. In that capacity, even if his recommendation is not considered, which my learned friend says they did not want to consider for whatever reasons, but the facts on this document is what is available with NEHU, Your Lordship. Now, here Your Lordship will kindly see, because my learned friend has interpreted the revision as one
Exactly.
movement and autumn as the second. And as such, I've already got two, so third MCP. Now, Lordship, as per their own showing, if Your Lordship will kindly come to see in this document under item 8.
Yes.
Because 7 is the total regular service from so and so, so 28 years. The date of first appointment 27/8/81, date of direct recruitment 27/8/81, Lordship. Now under 8, Your Lordship, can you see? Number of promotions, upgradations already received to the adjusted against ACP 1. So this is a document dated 26/8/2009, Your Lordship.
Yes.
On that date, as per the records maintained with the NEHU authorities, admittedly, I have only got one upgradation, Your Lordship. It is on their own showing. One upgradation. That is the autumn upgradation. They have written also. So, now the revision, and because of which that revised scale was given, that is not an upgradation, and they are admitting that fact, Your Lordship. I have only got one upgradation as on this date on 26/8/2009. And as such, Your Lordship, they are recommending that second financial upgradation under ACP is to be given to me.
It's just a moment.
I have only got one, so kindly give.
Just a moment. I think in some of these related cases, you have that pay commission recommendation.
Is there, my lord?
I think you have that pay commission recommendation where these the tables are there. As far as technical assistance is concerned, what was the pay revision affected? And I believe that sooner or later it was accepted by UGC and NEHU. Okay.
I'm sorry, Your Lordship, I just missed out on what Your Lordship has.
No, I am just saying, as far as your contention on the fact that 4,500 is the pay revision, so that must have been reflected in the pay commission recommendation, which was eventually accepted by or adopted by NEHU, by UGC direction, whatever. Is there that table is here? Is that table here?
Lordship, that if this particular rated is not there, the tables are available with us, Lordship, I can place it.
Okay. So this 4,500 is the fifth or sixth? Fifth pay commission.
Lordship, I'll place the scale here. I'll place it, Lordship. I'll get the document, I'll place it, Lordship.
But Mrs. Sen, you have.
Only small clarification, my lord.
No, you have this.
It is there in the writ petition, my lord. This what is saying absolutely wrong, my lord. This is a revised pay scale. Lordship will kindly come to, my lord, the pay scale are there, page 23. All the pay scales are there, fifth pay commission. And just Lordship, side by side, Lordship will look into that table in my written argument. This is not revised, this is upgradation, your lordship. Now, his initial appointment, my lord, was 81. Under third pay commission, he was doing 262, 350. In fourth, my lord, fifth pay commission, this became 3050 to 4590. Now, lordship, kindly come to page 23. 30250 to 4. This is at serial number 5. This is a pay scale, revised pay scale, my lord. This is a revised pay scale, lordship. And this person on redesignation, he has been placed 4,500 to 7,000. Now 4,500 to 7,000 is, my lord, scale 8. He got a quantum jump, your lordship. He is not supposed to.
He was in 5.
My lord, he was in 5, that is 4590. Now, my lord, what happened? Lordship, on redesignation, he was granted 4500 to 7,000. Now 4500 to 7,000 is at serial number 8. So these are the quantum jump. We, the university, my lord, they are not our enemy. Whatever possible, my lord, something we go out of the way to give them. Subsequently, we got it regular. Going by SAP from 5, he should have come to 6. But way of redesignation, we have given him a, my lord, huge financial benefit. He came to 8. And what my learned friend is saying, this is revised, absolutely wrong. Look into her own documents. Now, what it has become on revision, my lord, is in the next page. Next to next page. After 6th. Lordship, come to page 25 at Annex 6.
Yes.
My lord, 3050, 4590 became 5,200 to 20,000, my lord. It became huge. Similarly, my lord, this 7,000, 4,500 to 7,000, my lord, that is a serial number 9. On revision, it became 5,200 to 20,200 with great pay of 2,800. So what my learned senior friend is terming that what I submitted is a revised, absolutely wrong, your lordship. These are all on record. This has been granted, my lord, by way of upgradation. And he got a quantum jump. From 5, he would jump to 8.
Okay.
Lordship, this
So
document
this is
my
wrong.
learned friend is referring to, this will not clarify anything because this does not show which post.
And anyway, my lord, when pay revision is fixed, my lord, this is
Exactly with regard to this particular post, what was the revision as per 5th pay commission and as per 6th pay commission? What I will place that, your lordship, specific to this particular post, because these revisions are, it is not the same for every post, your lordship. So it has to be.
Yeah, there are those part A, B, C, isn't it?
My lord, whatever it may be, lordship, my lord, see, so far this, my lord, hearing, my learned friend can place these documents and all, your lordship, with the courts. But so far this hearing is concerned, lordship will conclude this hearing, my lord. I have filed my written argument, now rest is up to your lordship, my lord. If she files any additional document, my copy may be given to me if I feel like, my lord, it should be.
So
Otherwise, lordship will conclude.
by your own admission, you are precluded from reply.
Everything is here.
Exactly.
If any additional, my lord, relevant documents come, perhaps.
If she files,
otherwise I don't.
If she files that particular document, which states the post of technical assistant as under the scheme of the revised pay commission recommendation as such and such and such, and you have already stated your ground.
Yes, my lord, I have stated.
If it is favorable to them, then so be it.
I don't think, your lordship. So, my lord, this is my humble summary. This is not a revision, my lord. This is clear upgradations. In fact, my lord, I have referred to this document in my written argument, just to assist your lordship how it is higher pay scale and not revised. I have referred in my. So that's all, my.
So you'll. What happened?
Some correction.
Please join.
Can't hear you.
Lordship, I was disconnected for a little while
Yeah.
from the High Court end. So, Lordship, I have not heard what has fallen from your Lordship.
No, what Mr. Sen was saying is you can file any other document to support your case, including what you are saying just now, the the specifics as far as the pay commission recommendation is concerned with regard to technical assistance, how they fit in the scheme of things. That is up to you, and you will not agitate on that.
And Lordship, I would like to place some citations by which this
Yeah, you can.
terms clearly differentiated: redesignation
And revision.
and this financial upgradation.
Yes.
So these are three different things, Lordship.
Anything that is helpful to the court will be welcome.
Lordship will conclude the hearing.
Yes.
Lordship, this other matter, would your Lordship want me to clarify, because here again these issues, and since this matter was heard long back, I think
I have filed my written argument in that case.
I have also
Same
filed,
thing,
but
that redesignation, 3 financial upgradation, Nehu letter.
so if I can address
No,
you
then we'll do one thing. Yes, just for the benefit of the court, just to refresh the court, not a full length hearing, just to remind the court certain salient features of the. So I'll hear on that. We'll hear it on Monday then. Monday.
No, small.
If you want to clarify on your stand.
My written argument is already there. Obliged.
deeply obliged.
And by Monday you'll be able to supply those authorities.
Yes.
And whatever.
Because getting these documents during the weekend, I might be a little handicapped. But I will try a lot. If I'm not, then I will seek further time.
That will just lengthen the.
No, let it be on Monday, Lordship. Let the matter remain on Monday.
Please.
Let it remain on Monday. We'll make an effort to.
Heard Ms. Apol and its senior counsel, assisted by Mr. For the petitioner. Also heard Mr. Sen, assisted by Ms. Libla or respondent Nehu. Hearing is concluded. However, parties have learned counsel for the learned senior counsel for the petitioner has submitted that certain additional papers and authorities may be allowed to be filed before this court to further clarify the matter, further clarify the issue in question. As prayed for, this is matter on Monday. The three of you, are you lawyers or you are not lawyers? You are advocates. Do you know the rule of conduct when you appear in court? Do you know about the dress code? Then why have you? You have just come. That's what they all say. My colleague Justice Sagi was remarking on this. When you come to court, you should be. We were taught when we were juniors. When you go to court, you should be properly dressed. It doesn't matter whether you participate in the proceedings or not. But if it is some intern, law student, reporter, whatever, it doesn't matter. But you do that. It is for your benefit only. Thank you.